Good afternoon, and thank you for joining us today, and welcome to the kickoff of V&E's 2024 Technology Series. My name is Milam Newby. I'm a partner in our Austin office, and I'm the head of the firm's global technology practice. The purpose of this series is to give our clients insight into issues and emerging trends that are impacting the technology industry, as well as technology companies. Today's presentation will cover employment law developments. With that, let me briefly introduce our panelists. We've got Sean Becker, Phil Tennant, and Andrew Cox, who are each lawyers in our employment section. And at this point, it is my pleasure to turn it over to Sean Becker. Thank you.
Thanks, Milam. And thanks, everyone, for joining us today. As Milam mentioned, Phillida, Andrew, and I will be covering some recent developments in employment law and that speak, we think, to our technology clients and the technology sector specifically. Phillida, Andrew, and I are each labor and employment lawyers. And one thing that we've noticed, one trend in the past few months, is we're getting more and more questions arising out of either judicial developments or regulatory developments where clients are saying, okay, we've heard that there may be significant changes coming up in three areas. One, restrictive covenants. So areas relating to non-competes, non-solicits, our NDAs. What can we do? What needs to change? What needs to be on our radar? So I'm going to talk a little bit about restrictive covenant developments and some trends we're seeing there. One trend that everyone is asking about is DE&I. In the wake of the Supreme Court's recent precedent, wait a minute, what can we have with respect to our DE&I programs? What's permissible? What can we do to help recruit, retain our workforce? And what is now going to be under new scrutiny? Phillida is going to speak to some of those developments. And then finally, we're seeing more and more regulatory oversight and new guidance potentially about the distinctions between independent contractors and employees and joint employment. So many questions are coming in about, well, wait a minute, who is our workforce? Who are those individuals that are providing services to us that we actually may have responsibilities to as an employer? So Andrew's going to speak to a little bit of what we're seeing in terms of joint employment and thinking about what are the trends in terms of who our workforce is and what does that mean for our day-to-day operations. So kicking it off and starting off with restrictive covenants, we think about restrictive covenants, non-competes, non-solicits, non-disclosure agreements, sometimes non-disparagement agreements. Oftentimes there's been a debate where a lot of the tech sector, you would hear from the West Coast or the Silicon Valley tech sector would say, well, of course, we've had such phenomenal success because California prohibits non-competes altogether. That encourages employee mobility, it fosters innovation, and that's why that an economy without non-competes is one that's conducive to the growth of tech companies. The other argument, which we've sometimes heard from proponents of non-competes, certainly in Austin and under Texas law, where non-competes are permitted, or sometimes from the New York or Massachusetts sector, is wait a minute, we need non-competes. And if we didn't have security of a non-compete, we wouldn't invest in our personnel, we wouldn't make long-term commitments. And so it's because we as an employer knew we had assurances that we were able to grow our workforce and grow our company. Well, this time last year, I think as most everyone is aware, the Federal Trade Commission introduced its proposed rule, and the proposed rule essentially to ban non-competes. So at the time, a lot of ink was spilled. A lot of people speculated and said, wait a minute, what does this mean? Does this mean that we can no longer have non-competes? And the answer is we're still waiting to see. So we're still in a little bit of limbo. As a means of just to refresh what happened, back last year, the FTC came out and said, well, wait a minute. Section 5 of the Federal Trade Commission Act empowers the FTC to ban unfair methods of competition. We are going to assume that that mandate means that we can propose rules that would scale back laws that otherwise impede competition. And we, the FTC, by a 3-to-1 vote, said we're going to propose a rule that would ban non-competes because we think that non-competes has had, an adverse impact on the economy, and it has forestalled competition. Under their rationale, the FTC said that if they got rid of non-competes, they believe that worker wages would increase by $300 billion per year. And they emphasized the fact that about 1 in 5 US workers had non-competes. So that's about 30 million employees. Now, the focus of the FTC's rule seemed to be on the fact that they believe that so many of the individuals with non-competes were lower wage workers, were hourly workers. They cited one 2014 survey that said that 53% of the individuals with non-competes were hourly employees. And so the theory there was that this really is an impermissible restraint on competition. But then the rule that came out, and most of you are likely familiar with this, but the rule was proposed rule, very strong. And it made it so that non-competes would have been precluded from agreements with almost all workers, whether employees or independent contractors, regardless of whether it's the lowest level entry level worker or whether it's the CEO of an organization. It was a one size fits all proposed ban. Even the sale of business exception. So as many of you may know, it can be pivotal to investing in a company to get some assurances that founders or owners of a company are subject to a non-compete. Well, the FTC's proposed rule said, well, we'll still allow for sale of business non-competes, but only with respect to those individuals who hold at least 25% or more of the interests in a company. So, think about that. You think about, especially so many tech companies have a cap table where their ownership is widely diffused, and there may not be anyone, or there may not be many people owning more than 25% of the interests, but you might very well think you need the assurances of a sale of business non-compete from key employees who own 10%, 15% of a company. The proposed rule would have said, well, those aren't permissible. Non-competes as defined in the proposed rule were broad, and essentially while the proposed rule said that non-disclosure agreements and customer non-solicits are generally permissible, they said that we're going to look from a functional analysis about what a restriction is, and we want to prevent contracts that effectively preclude workers from working in the same field after they leave one company. And so by ways of example, they said even a confidentiality agreement that is written so broadly that it precludes someone from taking another job in the industry, that could be impermissible. Another example was in the proposed rule was a requirement in a contract that requires someone to pay back training costs to an employer if they leave in a certain amount of time. Well, if that has the effect of chilling movement, and it's the costs themselves aren't reasonably related to what the employer provided, then that too could be an impermissible non-compete. So unsurprisingly, I think as we all know, the U.S. Chamber of Commerce, a lot of industry groups said, wait a minute, this is a gross overreach of regulatory authority. There is going to be opposition. There was then an extended rulemaking process. 27,000 public comments were received on the proposed rule. And the latest that we've heard, the guidance is that the final FTC vote on whether or not to promulgate a rule is likely to come sometime this spring, likely in April. If the rule banning non-competes is implemented, there would be a 60-day gap before implementation. At that point, we should fully expect that litigation will go full speed ahead, and we'll wait and see whether or not a court would enjoin the rule. Certainly we've seen federal courts in the past year, 18 months, have not received wide-reaching federal rules very warmly, and so I do think it's highly likely that the rule at some level would be enjoined. But we just need to wait and see, with respect to what's going to happen. So stay tuned. But in the meantime, that's the FTC, and I think everyone was aware of what was happening at the federal level with the FTC. Under the radar, another federal agency opined in the past year with respect to non-competes, and that's the National Labor Relations Board. And you might be saying, well, wait a minute, That doesn't matter to me. I'm a tech company. I don't have a union. Well, the National Labor Relations Board weighed in because labor law does in fact apply to every employer, even if you are non-unionized. And specifically, Section 7 of the National Labor Relations Act creates protected rights essentially for non-supervisory employees to engage in activities for the purpose of either collective bargaining or for concerted activities for mutual aid and protection. So that's a protected right under labor law, even for non-unionized, non-supervisory employees. The National Labor Relations Board's General Counsel in May of 2023 issued an advisory opinion in which she said, it's my belief that the entry into non-competes as a requirement to either have an employee keep their job or as part of a severance arrangement, that is impermissible under Section 7 of the National Labor Relations Act if it has the effect of chilling employees from exercising their rights to engage in in activity for mutual aid and protection. So by way of example, her memorandum said that if the fact that employees know they have non-competes and that chills them from leaving en masse and going to a new employer, or it chills them from engaging in a strike or a lockout or another labor dispute because they don't have the economic mobility, or if they're discouraged from threatening to resign or discouraged from speaking up because they know that they're precluded because of their non-compete from banding together at a new competitor or otherwise seeking other employment, then I think that violates Section 7 rights. So the General Counsel of the NLRB puts out this advice, this memorandum, and essentially tells the people within the NLRB in the field to be looking out for potential cases to bring. And it speaks to, we haven't seen much development since then, but this is a warning, and it highlights that for any employers, even non-union employers, well, wait a minute, we know that we have the National Labor Relations Board looking at non-competes. Should we look at who we have non-competes with? Do we have non-competes with non-supervisory employees? Do we think the effect of those non-competes could be deemed to chill these protected rights? And if so, do we want to scale back our use of non-competes? Now, the memorandum did say that this does not apply to non-competes that are entered into with true independent contractors, nor would it think that, nor does the General Counsel think that non-competes that would only restrict ownership interests or managerial roles with a competitor would implicate labor law, as it's talking as those types of restrictions speak to ownership, supervisory, managerial related roles. But again, this was a warning that sort of came out of the blue about another federal agency looking at non-competes. So something to be mindful of, even for the non-union employer. But wait a minute. Now, also, what developments do we need to think about, especially if we are a national employer or if we're looking to have a remote workforce? And for so many of our tech clients, there are remote workers, and there are increasing number post-COVID of employees who are working across the country, working under a patchwork of different state laws, even if they're contributing to a client based in New York or based in Texas. They could be in California, they could be elsewhere. And so that's why developments with respect to California's non-compete statute are particularly relevant for all employers, but especially those who may have employees in California or employees who may look to compete in California eventually. So California Business and Professions Code 16600 is the longstanding California prohibition that flat out prevents non-competes. There's a limited exception for sale of business non-competes, but for your employment-related non-compete, that is void, and that has been void for a long time. So what's changed? Well, effective January 1st, 2024, two brand new laws took effect. The first was Section 1600, the non-compete law, was amended and it was expanded so that a new provision provides that any contract that is void under the prohibition against non-compete law is unenforceable regardless of where and when the contract was signed. What does that mean? Don't try to come to California or don't try to enforce within California your non-compete, even if it was signed with an employee who was outside of the state at the time, even if you were an employer who was based outside of the state, and even if the choice of law in that contract didn't designate California law. And there's going to be an interesting potential fight if the enforceability of this law is challenged under some sort of Commerce Clause type challenge, as this is a far-reaching potential statute. But notably, the statute also said, not only are we going to say that the contracts are void if they have a non-compete, but it's also prohibited to actually enter into agreements that are void. So the mere act of entering into the agreement is now unlawful, and it's now unlawful to seek the enforcement of any agreement, any non-compete that is void. There are new remedies available. So in addition to potential damages for someone who is prevented from competing or has to incur attorney's fees, there are mandatory attorney's fees award for employees or former employees who try to challenge a non-compete that otherwise purports to apply in California. There's also an affirmative obligation upon employers who have non-competes that would apply in California to their current employees or former employees who were employed after January 1st, 2022, to actually send an individualized notice telling employees that those non-competes aren't enforceable and are not in effect. And it's actually an unfair competition, act of unfair competition in and of itself not to send that notice. So it's shot across the bow from California that it really means it with respect to non-competes. Other developments, state-specific developments about what we can and can't do. You may have read about, you might have heard about the New York proposed statute. So this summer, June 2023, both the New York, their assembly, essentially their House, and their Senate, each approved a bill that went to the governor's desk. It was a wide-reaching bill. It provided that non-competes essentially would be unenforceable, and that included agreements with any employee and any other contractor or worker who was economically dependent upon and under an obligation to perform duties for the company. Pretty broad standard. Just like the proposed FTC rule, the New York bill applied equally to your chief executive officer and your lowest level your lowest level intern, entry level employee. So it was an across the board proposed ban. Very significant. There was a limited carve out allowing for some client non-solicits, but people in the business community were watching this very, very closely, as this could have significantly limited what you can do in New York going forward. Quietly on Christmas Eve, Governor Hochul vetoed the bill and put some coal in the stocking of the proponents of that bill. But in vetoing it, she emphasized that she continued to recognize the need, she said an urgent need, to restrict non-competes for middle-class and low-wage workers, and she's open to future legislation. What we've heard is that there's a debate between the executive, between the governor and the assembly as to whether or not the threshold for permissible non-competes should be $250,000 per year, $300,000 per year. But I fully expect sometime this year to see this bill come back, and likely to be a bill that would prohibit non-competes with lower wage employees. The only question is, what is that wage? Where's that appropriate threshold? So again, stay tuned. Very high level, other state-specific trends for us all to be aware of, what we are seeing, what we need to think about when drafting. Ask yourself, where do we have remote employees? Where do we have employees that have a non-compete, that have a non-solicit, or where do we think they might go to compete? Are there state-specific considerations that we need to think about when drafting or reviewing our non-competes? July 2023, Minnesota joined the list of states that flat out prohibit non-competes. That statute applies to both employees and independent contractors. It does not prohibit non-solicits. It does not prohibit non-disclosure covenants. But again, Minnesota now joins California, North Dakota, and Oklahoma as 4 states that flat out prohibit non-competes. Other trends we are seeing with state-specific legislation from the past few years, where you'll see statutes saying there must be wage thresholds, not unlike what we think might come in New York with respect to who can be subject to non-competes. So Colorado, Illinois, Washington, all state-specific requirements essentially saying if you're going to be subject to a non-compete, you have to be having at least a certain amount of guaranteed income per year. We're also seeing statutes, again, Illinois, Colorado, most notably, with really extensive notice requirements before you can enter into a non-compete or in order to have an enforceable non-compete. So employers need to make sure that they've checked all the boxes with respect to putting prospective employees or new employees on notice that they're going to be subject to non-competes. We're also seeing, again, specific statutes saying if there's a dispute arising out of a non-compete, then if an employee is in X state, Massachusetts, Colorado, Washington, then the dispute resolution clause of that non-compete agreement and the choice of law both have to relate to that state in which the employee resides. And in general, courts are looking at non-competes, including Delaware courts, including areas where we historically have thought were favorable to non-competes. Other issues to consider. I do see your poll is coming up, so please make sure to get your CLE credit. Other issues to consider with respect to restrictive covenants. Employee non-solicits. Well, are those the same as non-competes? Are they subject to the same level of scrutiny? In Texas, yes, and they have been for a while. In other states, it depends. Many of the state-specific statutes have carve-outs saying these do not apply to employee non-solicits. Some say they do apply. Regardless, though, again, we're seeing courts look at employee non-solicits and be closely and be less enthusiastic about enforcing them if they're deemed to be overly broad. Finally, confidentiality covenants. Back to our friends at the National Labor Relations Board. There was a case that came out in May 2023 called McLaren-McComb, where the National Labor Relations Board looked at a confidentiality agreement that an employer required 11 unionized employees, or it asked 11 unionized employees to enter into as part of a separation agreement without consulting with the union first. It said, here's your separation agreement, and it had a confidentiality clause that said, the terms of this agreement are confidential and the employee agrees not to disclose them to any third person. Well, remember what we said about Section 7 about having a protected right to share information and to act for the mutual benefit of fellow coworkers? That extends to sharing information about terms and conditions of employment. The NLRB said, that's too broad, that violates labor law. So again, we're seeing more scrutiny on your confidentiality clauses. We need to think about whether they overreach. Similarly, we're seeing federal government look at, okay, are there necessary SEC carve-outs? Are there necessary regulatory carve-outs that make plain individuals, even if they can't disclose business information, need to be able to share information with regulatory agencies if they think there's been a violation of law. Same thing, labor law considerations, also getting into non-disparagement covenants, where the NLRB has said, flat out prohibitions against making statements that could disparage or harm the image of an employer. That's too broad, getting into protective activity. And we're seeing more and more states say in settlement agreements, non-disclosure agreements, any generic confidentiality agreements, there do sometimes need to be carve-outs to allow for making statements about perceived sexual harassment, discrimination, unlawful activity, especially for us the multi-state employers among this group. We need to be thinking about, are those carve-outs addressed and are there state-specific concerns we need? So that's a lot. I was going to say, we'll now do a hard pivot and get to one other sort of bucket, one other area of questions that we're getting a fair amount, and that's with respect to the DE&I environment. And with that, I'll turn it over to you, Phillida.
Thank you, Sean. Actually, I was, during your presentation, trying to think of how to pivot, and I realized I don't think it really is a hard pivot. So I think that what ties these two topics together is maybe not a race for talent overall, but it is certainly does touch on the same topic of how do we attract and retain the right talent, restrictive covenants being a way for an employer to feel comfortable investing in its workforce. And I think DEI initiatives are sort of along those same lines. So that was my tie between our two topics. So nix what Sean said about the hard pivot. So it was, when I was writing these slides, all of a sudden a whole barrage of new articles started coming out in the Financial Times, Reuters, about what people are talking about in terms of DEI, which, as I should have said earlier, stands for diversity, equity, and inclusion. And the Financial Times, there was a business editorial that said, companies are rethinking inclusion policy. And so the goal with this first slide is really to orient you guys to the extent that you're not already about what people are focused on. Outside, what is the public focused on in terms of DEI? What are lawmakers focused on? I think from a business perspective, like, for example, in the Financial Times article, what people are focused on is, I think, the realization that they want to see return on investment on DEI programs. And in order to effectively see that return on investment, they really do need to be legally compliant, and they need to be communicated to the external public in a way that makes it clear that they are legally compliant. And then separate aside from that, and that's where you guys come in, is making them work for your own business. And separately also, I saw an article this morning that was quoting a CEO of a very prominent bank who was at a World Economic Forum last week, and he described himself as I'm quoting, red-blooded, unwoke capitalist CEO. But the point of his talk was to talk about how his bank plans to continue DEI efforts. The quote that he went on to give about what DEI efforts could be for a company is that some work and some don't, but what it comes down to is whether or not you're just giving it lip service. So the goal for my slides is to talk about some of this increased external focus on DEI, and then talk a little bit about how we can hopefully help support you guys in making DEI programs that not only achieve the specific DEI goals that your business might have, but results in not just giving lip service or not to the concept, but in all events, doing so in a legally compliant way. So slide. The first bullet point here on the slide is the case name, and it's SFFA Inc. versus Harvard College. And this is the case that launched basically this entire discussion. While my practice has involved a lot of ESG, environmental social governance work, the focus on DEI programming, which falls within that S, the social portion of that moniker, really picked up right around this Supreme Court of the United States decision, which came out in the middle of last year. And the case specifically had nothing to do with what my legal practice is, or at least so I thought at the beginning. It has to do with affirmative action. Affirmative action, for those of you who don't know, basically was a creation of the Supreme Court itself back in the 70s, which allowed colleges to take race into consideration for purposes related to admissions. And this, the case by the Supreme Court last year, basically overturned that and said, we're not allowing colleges to take race into consideration in admissions going forward. Again, not my bailiwick, but what I do know is that the case really had nothing to do with employment decisions by private employers. And so it's been very interesting to me to watch how this has unfolded. And very soon after the announcement of that decision, you started to see editorials about how this is going to impact private employers, and people are going to try to apply it to businesses. And I'm sitting here thinking, how on earth is that all going to pan out? Like, this really has nothing to do with it. But I will say, and I don't really have the answer to how is this going to impact my practice, but I certainly have seen an increased focus for employers on asking the question. So the EEOC weighed in soon after this decision and said, guys, it remains lawful for employers to implement diversity, equity, inclusion, and accessibility programs that seek to ensure workers of all backgrounds are afforded equal opportunity in the workplace. So the EEOC, as you all know, is the government agency in charge of enforcing laws related to anti-discrimination. And this is basically them weighing in and saying, hey, you can still have programs that aim to implement diversity. This decision did not change any of that. Nonetheless, like I said, anti-ESG backlash soon followed this decision, basically seeking to expand it or apply it in ways that moved it beyond its university affirmative action focus. The first bullet point I have here is political scrutiny from politicians, media, and activists. The first thing that we started to see was employees looking to their leadership to make some statement about what diversity meant to them in the workplace. We saw a lot of companies, for example, I'm thinking of a big one in Florida, who spoke out against legislation related to, again, education, teachings around diversity. And that company ran into some tax break reductions and lost some potential development incentives, or at least so the news has reported. So we saw a lot of pressure from employees for CEOs and leadership to speak out. We also have seen a lot of pressure from state attorneys generals who, on both sides of the aisle, have published letters objecting to different pieces of legislation or work that has gone on related to DEI. And more specific, perhaps, to my practice and things that I can actually do something about, is we've seen anti-DEI advocacy groups bring or fund litigation. So, for example, we've seen certain DEI advocacy groups that have threatened to file sending cease and desist letters, or actually filed litigation against companies, arguing that what they describe as the members of their groups have been prohibited from applying from opportunities, for example, for an internship or a fellowship that might be described as like a diversity fellowship with a particular company, because they are not themselves a member of a historically underrepresented group. And so they file a lawsuit alleging that they have been denied those opportunities to apply for those programs. We've also seen these same advocacy groups file charges with the EEOC, claiming that they have been subject to what's called reverse discrimination. So there are anti-DEI advocacy groups out there who have funding either from private individuals, or probably largely from private individuals, who are currently engaged in filing these lawsuits or threatening to file lawsuits against private companies for limiting opportunities related to employment to those who are members of what we might call historically underrepresented groups. So that is what the current increased external focus is on DEI. This slide, my goal on this slide was to walk through the different places where we, V&E, try to come in and help employers think through how they are presenting their DEI efforts, because it's through that presentation that, for example, external advocacy groups or any of your other stakeholders, employees, will come to know what your DEI efforts are and how they will form their opinions about whether or not they are legally compliant. So the first touch point that we usually work on with employers is just reporting. And that can either be legally required reporting. For some people, that's financial reporting, such as to the SEC, where disclosure of, for example, human capital management risk factors has long been a thing. The second sort of touchstone within that is what I call elective reporting. So ESG reports. And ESG reports or sustainability reports may not feel elective due to external pressures, but in effect, there's not necessarily a law that is requiring the S component, the social component, the DEI component, to be included in that reporting. So we will often, many times, help employers review how they're presenting their DEI efforts within those reports. Websites are another big one for me. I think it is very important for companies to make sure that what they're saying about DEI on their website is compliant and does align with what they're actually doing. And I think it can, ironically, in an internet age, it can be a bit of a forgotten touch point when it comes down to editing. And my goal, or our goal, with respect to reviewing this kind of reporting is to make sure that what you're reporting is accurately reflecting your actual business practices and accurately reflecting your aspirations for your DEI efforts, all in a way that is compliant. And in doing that, I have listed here a number of stakeholders that we often get asked to take into consideration. And so a frequent question when we're working on reporting is, okay, well, who are the stakeholders that are going to receive this? It's not a given that something is public. It's not a given that it will be distributed to employees. It's not a given who will receive it. And have you determined who you want to receive this reporting that describes your DEI efforts? Certainly, institutional investors can be a huge driver for our clients in terms of making disclosures around DEI. And that is something that can often require us to spend time thinking about how it is that we're going to do that in a way that satisfies the need of those investors and lets you get your business done and is also compliant. I think also it's important to flag, business partners and local communities. I think the kind of documents that I see those come up in, for example, will be supplier codes of conduct. I think there's a real trend right now to people taking a hard look at their supplier codes of conduct and figuring out how exactly, and also their supplier contracts, how exactly they want to wrap in the requirements that they have for their business partners related to DEI or other ESG parts, frankly, into those contracts or into those codes of conduct and how those documents are intertwined. And then last, I have local communities here. I've seen a lot of work recently related to describing the efforts of companies who interact very frequently with Indigenous peoples, perhaps due to oil and gas operations on reservations, land. So I think that all those, documents describing those interactions, those can all be very important touchstones for members of those communities and need to be taken into consideration legally as well. So then last, I have here policies. Lately have been, gladly, because I've enjoyed doing them, writing and editing a lot of ESG policies and diversity policies, which I think are very interesting because historically, right, employers have had anti-discrimination policies, but now we're seeing a proliferation of new kinds of policies related to how a company focuses on ESG and diversity. The legal framework, I'll just keep this simple. I think we all know what it is. Number one, Title VII of the Civil Rights Act. You must not discriminate. There is a concept for voluntary affirmative action programs within Title VII. It's very rare. You should talk to a lawyer before you assume that you have or can have one. Reverse discrimination, which means it has been used to coin the phrase of basically discrimination against people who are not historically discriminated against, for example, white people, is also a legal concept under Title VII. Section 1981 prohibits discrimination in the making of a contract. I expect that in the public anti-DEI efforts, we will see more talk about Section 1981 in the future. Corporations have corporate directors and officers have certain fiduciary duties to oversee the DEI efforts of their companies. We've seen claims related to that. Federal contractors and subcontractors may have affirmative action requirements. And last but not least, California, first to the march in many things, is passing legislation related to the disclosure of diversity statistics. Briefly touching DEI on boards, there is a NASDAQ board diversity rule, which went into effect at the end of last year for companies traded on the NASDAQ. They need to be aware of this. It does require disclosure related to why a company of certain size has not fulfilled certain demographic requirements, or alternatively to fill them. I think that's definitely something to work on with your corporate team if you are trading on the NASDAQ. Next steps for DEI and technology companies. I've seen headlines about cutting DEI at tech companies, but as far as I can tell, I'm not exactly sure where they're coming up with that, but I think it's mostly based on layoffs where like personnel with DEI and their job titles were included. But I would suggest that now really is the time to do a holistic review of any internal document that you have related to DEI. And as part of that, I think your goals are three things. Your number one goal is legal compliance. Your number two goal is being accurate in the way that you describe those legally compliant DEI programs. And your goal three is to be precise. And in being precise, I mean coming up with a way that DEI programs can help support, help create return on investment that allows you to retain that diverse talent that I think many studies have shown will actually help increase the profitability of your business. And so with that, I will turn it over to Andrew to talk about other legal risks that your company should be aware of.
Thanks, Philda. And unlike Philda, I will take the opportunity to have a hard pivot from the DEI to independent contractors and joint employer analysis. As priorities among workers and businesses change, including the premiums both workers and businesses place on flexibility, the relationship between a business and its workforce has become increasingly more complex. Gone are the days where a company directly employs its entire workforce. Companies now have an array of different types of workers. This is particularly true in the tech industry, where the high demand for short-term workers of limited engagement and need for remote work doesn't always mesh well with traditional employment relationships. So in addition to traditional employees or W-2 employees, we can go to the next slide, sorry. Companies will often engage individual independent contractors, consultants, or contingent workers, often referred to as 1099 contractors. More still, some companies will obtain labor from staffing agencies or other entities through a services agreement, wherein the staffing agency or other entity will provide the employers. And when in the course of diligence or consultations, we'll oftentimes see companies only treat workers that they issue W-2s as employees, while treating workers that are engaged through alternative work engagements as either independent contractors or the employee of the entity providing the labor. But is that always accurate? With apologies for the typical lawyer response, it depends. We can go to the next slide. But before we dive into the relevant tests, I wanted to put this slide together, to kind of, I guess, scare you into compliance, right? Like, as you may imagine, employees are entitled to significantly more protections under federal and state law than independent contractors. And some of the statutes listed on this screen provide a good example. For example, with the FLSA, employees, not independent contractors, are entitled to various minimum wage, salary, and overtime requirements. Employees are protected from discrimination under certain discrimination statutes, and they're entitled to job-protected leave under the FMLA. And employees, not contractors, have rights under the National Labor Relations Act, including the right to self-organization, to bargain collectively through representatives of their own choosing, and to engage in concerted activities that Sean mentioned previously. There are also state analogs to many of the laws referenced on this slide that are only applicable to employees. Companies also have certain obligations with respect to employees that they don't have for independent contractors. You got to retain various records, both during and after employment. You have to verify whether your employees are eligible to work in the United States. And companies are required to provide numerous types of notices to their employees, particularly with respect to various types of leave and rights under discrimination law. And as I'm sure we're all familiar with after reviewing our first paycheck from our first summer job, employers have the distinct privilege of withholding certain amounts from their employees' paycheck for various tax and insurance obligations. And it's important to bring home here that there are real tangible consequences for misclassifying workers as an independent contractor, or if you're deemed to be a joint employer. Briefly, the damages related to independent contractor misclassification under the FLSA include the amount of minimum wage and overtime pay owed, and typically also include liquidated damages that can double the wages owed. The FLSA also provides for the award of attorney's fees to employees. Let you fill out your poll here. In some instances, state laws also impose penalties above and beyond those provided under federal law. Relatedly, joint employer could be deemed jointly liable for a third party's employer's failure to abide by their employment-related obligations. And in some instances, joint employers can also have an obligation to collectively bargain with the union of the third party's employees. We can go to the next slide. So how do we determine whether a worker is our employee, an independent contractor, or someone else's employee? Life would be simpler in my presentation, much shorter, if the label the parties gave the relationship was determinative, but that's not the case, even though contractual provisions clarifying the parties' relationship is helpful. Whether your independent contractor is your employee or whether you're the joint employer of your favorite staffing agency is a highly fact-specific inquiry. The relevant tests generally focus on the economic realities of the parties' relationship and the level of control the putative employer exercise over the workers at issue. If you noticed, I used the word tests plural, not test singular, and added every lawyer's favorite word generally. That's because companies hoping to determine whether a particular worker is an independent contractor or whether they jointly employ the employee of their service providers must familiarize themselves with the quagmire of multi-factor tests that vary from one context to another. For example, the test to determine independent contractor status under the federal tax law is not the same as the test applied under the FLSA. And the test applied under the FLSA is not the same as the test applied under California wage and hour law. Different tests, courts applying varying interpretations of such tests, and regulatory rules that seemingly change with each new administration creates an ever-evolving patchwork of laws that can end up having a worker qualify as an employee for some purposes and an independent contractor for others. In the next slides, I'll briefly describe some of the more noticeable changes. It would be a fool's errand to try and describe to you all of the applicable independent contractor and joint employer analysis in the limited time we have. And so I'll focus specifically with respect to recent developments in the Fair Labor Standards Act, the National Labor Relations Act, and a certain trend developing amongst the various states. Next slide, please. So as you can tell from the FLSA definitions on the slide, the question of whether a worker is an employee under the FLSA hasn't been clear since the statute's enactment. As a result, courts developed the common law economic realities test to guide their determination as to whether which is a totality of the circumstances test, with the ultimate inquiry being to determine whether, as a matter of economic reality, a worker is economically dependent on the putative employer for work, and therefore an employee, or is in business for themselves, and therefore an independent contractor. Although there might be slight differences as to how the factors are framed or the number of factors considered, courts generally look to some variation of the 6 non-exhaustive factors on the slide to aid them in their analysis, with no factor or factors having predetermined weight. The Department of Labor's approach, which, as we know, is the administrative agency set with enforcing the FLSA, to independent contractor classification largely mirrored that of the common law economic realities test until early 2021, when under the Trump administration it issued its first independent contractor rule, which differed from the common law economic realities test in several substantive ways. Instead of 6 factors, the 2021 rule only listed 5, no longer considering the party's investments as part of its analysis. It divided the remaining factors into core factors and non-core factors, providing increased weight to the core factors, which were the degree of control exercised by the putative employer and the worker's opportunity for profit or loss. The 2021 rule also included a provision that provided the party's actual practice was more relevant than what may be contractually or theoretically possible. But the 2021 rule might not be long for this world. On January 10th, 2024, the DOL issued a new final independent contractor rule, which both rescinds the 2021 rule and, according to the Department of Labor, restores the traditional economic realities test courts have relied on for decades. The 2024 rule does away with the core factor, non-core factor dichotomy and restores the party's investment as a 6th factor of consideration. The 2024 rule also includes guidance as to how the DOL will evaluate each of the 6 factors, with some of the more notable guidance relating to how the Department of Labor will examine the factor related to the potential employer's control. Unlike the 2021 rule, which placed a premium on actual control, the 2024 rule expressly states that the DOL will consider the amount of reserved control the potential employer has over the worker, including whether the potential employer reserves the right to supervise or discipline workers or place demands or restrictions on workers that prohibit them from working for others. Think about those non-competes that Sean mentioned, or working when they choose. The potential employer's control over economic aspects of the relationship, including control over processes or rates for services and the marketing of the services or products provided by the worker, will also play a part in the DOL's analysis moving forward. The 2024 rule is currently scheduled to take effect on March 11th of this year, and although the rule is almost certainly going to be challenged, employers would be wise to re-examine their independent contractor practices, particularly with an eye towards the factors and commentary provided in the 2024 rule. Next slide, please. So to back up to the National Labor Relations Act, the National Labor Relations Board, as Sean talked about previously, has also recently changed its independent contractor practices as well as its joint employer analysis. Traditionally, with respect to its independent contractor analysis, the NLRB relied on the common law agency test to determine whether an individual was properly classified as an independent contractor under the NLRA. Under that test, the board looked to several exhaustive factors enumerated in the restatement of agency, which would include some that we're all familiar with, right? Like the extent of control exercised by the potential employer, the skill required to perform the work, the duration of the worker's engagement, the method of payment, just to name a few. But while those factors have generally remained a part of the NLRB's analysis, the NLRB has evaluated those factors through varying lenses over the last 15 years, with the board altering its analysis multiple times, usually in connection with the change in the presidential administration. The most recent installment in the National Labor Relations Board independent contractor saga came about this past June in a decision involving the Atlanta Opera's classification of makeup artists, wig artists, and hairstylists as independent contractors. Under the test set forth in Atlanta Opera, the board first considers all the aspects of the parties' relationship in light of the restatement factors, but then it engages in an independent business analysis that considers the worker's entrepreneurial opportunity, as well as whether the worker has a realistic ability to work for other companies, has proprietary or ownership interest in their work, and has control over important business decisions such as the scheduling of performance, the hiring, selection, and assignment of employees, and the purchase and use of equipment, and the commitment of capital. In Atlanta Opera, the board also clarified that any weight given to entrepreneurial opportunity moving forward must be actual, not merely theoretical, and must take into account any restraints the potential employer imposes on the worker's ability to render services. The NLRB standard for deciding whether two entities are joint employers historically also relied on a set of different but related common law principles, which focused on whether the putative joint employer shares control over or co-determines the worker's employment terms and conditions and actually exercise the right to control. However, since 2015, the board has switched back and forth between standards that either emphasized or de-emphasized the potential joint employer's indirect and unexercised control. On October 27th of this year, the board issued a final rule that once again permits an entity to be deemed a joint employer based on unexercised control. Specifically, the 2023 rule provides that an entity will be deemed a joint employer if the entity possesses the authority to control or exercises the power to control one or more of the employee's essential terms and conditions of employment, which the rule defines to include wages, benefits and compensation, hours of work and scheduling, the supervision of the performance of the duties, the assignment of duties to be performed, and working conditions related to safety and health, just to name a few. The rule makes clear that merely possessing the authority to control one or more of a worker's essential terms and conditions of employment, even if that authority is never exercised, is enough for a putative employer to be deemed a joint employer under the NLRA. This 2023 rule rescinds the board's 2020 rule, which required evidence of substantial, direct, and immediate control of an essential term or condition of employment before finding a joint employer relationship. 2023 rule also clarifies that a joint employer of particular employees has an obligation to collectively bargain with the representative of a joint employer's employees with respect to those terms or conditions of employment that it either possesses the authority to control or exercises the power to control. The 2023 rule is currently scheduled to take effect on February 26th of this year, but is already the subject of multiple legal challenges. Next slide, please. So as Sean mentioned earlier, we know that tech companies are particularly prone to hiring remote employees. And so state law considerations, are key in this area as well. State law governing independent contractor classifications vary from state to state, with some states, including Texas, using some version of the common law right to control test, particularly when it comes to performing the analysis under the state's wage and hour laws. But over the past few years, more and more states are adopting what's commonly referred to as the ABC test, with California, who applies the test to its entire labor code, being perhaps the state most commonly associated with the test. Under the ABC test, a worker is presumed to be an employee of the hiring entity unless the hiring entity can demonstrate three things: that the worker is free from the hiring entity's control and direction, that the worker performs work that is outside the usual course of the hiring entity's business, and the worker is customarily engaged in independently established trade, occupation, or business of the same nature as the work that they're performed for the hiring entity. As you can imagine, this is a very difficult standard to meet and often results in a worker being classified as an independent contractor. So next slide. So best practices. What can companies do real quick to minimize risk, particularly given that recent employee-friendly trend in law? To minimize the risk of independent contractor liabilities, companies should periodically audit their contractor classification and practices to ensure that they are in compliance with the applicable standard, which we've seen is changing with increasing frequency. Companies should also centralize their classification decisions to ensure consistency across their organization. Trying to convince a court or government agency that two workers performing the same job should be classified differently is not a place you want to find yourself. Limiting engagements with individuals to establish businesses will also help alleviate concerns that the individual is economically dependent on the company. Turning to joint employer risks, the company should audit its staffing and services arrangements because, with limited exceptions, a company's joint employer's liability largely stems from the payrolling entity's non-compliance. Forming diligence on employee vendors, therefore, is paramount to avoiding joint employment liability. Companies should also train their managers on joint employer principles in an effort to reduce the risk that such managers exert employment style control over a vendor's employees. And companies should review their third-party agreements to ensure that the authority over the vendor's employees is properly reserved for the vendor, and that the vendor is responsible for providing compensation and benefits to its employees as well. Staffing agencies and services agreements should also include strong indemnity language, where the vendor agrees to indemnify the services recipient for any and all employment-related claims and promises to comply with employment-related laws. We've also seen a growing number of enterprising plaintiffs' lawyers try to circumvent the arbitration and class action waivers that are commonly found in staffing companies' employment agreements by going after staffing companies' clients that the workers provided services for. Companies can reduce this risk by ensuring that the staffing company's arbitration provisions are clear, that they also apply to any employment-related claims the staffing company's employees may have against its clients. And with that, I will turn it back over to Milam with another hard pivot.
Great. Well, I'll do a little bit of a bridge here before we pivot. I guess just real quickly on the deal perspective, the last piece that Andrew was covering on classification is probably the most common issue we see when we're buying and selling tech companies. And so just a plug for looking at the classifications on the front end, because it's as I mentioned, the most common area for indemnities and post-closing recourse in the employment area. We have hit the hour, so I will conclude the presentation. Thank you again for everyone for joining us today. Be on the lookout in your email for a copy of the presentation and deck in the coming days, and we look forward to seeing you in the second quarter for our next presentation. We're targeting a discussion around executive compensation and equity compensation issues. If there are topics that you would like for us to cover for the tech industry and tech companies, please don't hesitate to send me a note as well. Thanks again for joining us, and have a great week.